Mr. Rogers.
Thank you. Before the lunch adjournment, your Lordship asked whether the capital or assets were used post-dissolution. To give a more detailed answer to that question, in respect to capital, no, there was no capital actually at the outset of this partnership, but any monies that were in the partnership bank account at the point of dissolution were in fact frozen and remained there until after trial. As to assets, there was some limited use by Mr. Hughes. Both parties, in fact, used the name Hughes Healthcare post-dissolution. Both sides, both Mr. Manduka and Mr. Hughes, for some period of time, not extensively long. It moved to Medical Supplies Direct. There was a period of time. The judge also found that Mr. Hughes Medical Supplies Direct Limited had used some literature that was prepared during the lifetime of the partnership. For example, some literature as to the performance of the ACOM Flowflex test. The judge actually made a finding that I think that the literature was put together by Frederick Manduka, and so that would also, of course, have been in Newfoundland's control and use as well. And of course, there was the website, which I think the court was taken to by my learned leader, and in fact, was taken to this point about the website at some point during the submissions. The website was pleaded, I believe, and in the defence and counterclaim, Mr. Hughes accepted that the website was partnership property. What essentially had happened was that it had carried on running in the background and that orders had automatically gone out that had been made over the website. So what Mr. Hughes said, and it's at tab 13 of the core bundle, page 337, he said that prior to being taken down, this is Roman 13, number 2, prior to being taken down, the Hughes Healthcare website generated £8,816 and a penny in sales. This is to be brought into account on a winding up, the website being a partnership asset. I'd set out a summary of the appellant's case on section 42 before the lunch adjournment. I'd set out the circumstances in which we say section 42 applies, the conclusion of the judge, and in order to make good those submissions, I intend to address your lordships and your ladyship as to, first, the proper construction of section 42 as a matter of law. Second, why we say that the judge misdirected himself. And third, where that misdirection leaves the judge's findings and what the appellants are inviting this court to do. If I could therefore begin with my first topic, if I can call it that, the proper construction of section 42. And I have 3 grounds to cover here. Of course, as I summarise, it is the appellant's case that outside of cases involving death, one partner has to have been left out or excluded, there has to have been an outgoing partner, leaving the others to continue the business. First, if I could turn up section 42 itself, that is at page 24 of the authorities bundle. What we have there at subparagraph 1, I submit, are 4 requirements. The first is that a party or a partner has died or otherwise ceased to be a partner, later referred to as an outgoing partner, which is perhaps a more elegant way of putting it. Second, that there are surviving or continuing partners. I note here that the section says partners, and the judge did ask this question at trial, but we accept that this section has been applied in cases in which there are only 2 partners. So that's not a question certainly for this court, but it could be a question, I suppose, for the Supreme Court one day, as to whether that that applies in a two-partner partnership. But we accept for the purposes of this court that it does. Third, that those continuing or surviving partners have continued the business of the firm with its capital or assets, or to use the words of the section, carry on the business of the firm with its capital or assets. And fourth, that that's without any final settlement between the outgoing partner and the firm, or the outgoing partner's estate and the firm. So that's my first point. That is what section 42 says on its face. Second, I want to look at how we say, as the appellants, that should be interpreted. Unlike section 29, which is directed at the liability of particular partners, section 42 and 43, which is just below it, and section 43 effectively it declares that the amount due from the surviving or continuing partners is a debt. Section 42 and 43 are built around the concept of what is happening with the business of its firm, business of the firm, and its capital and assets post-dissolution. You've got the surviving partners, the continuing partner, and the business being carried on with its capital and assets. So I say this is being viewed from the perspective through the lens of what is happening to the firm post-dissolution rather than a particular partner. It's also our submission that it's inherent within the wording of section 42 that the partnership business has to have been continued to the exclusion of the outgoing partner. And we say that is the plain reading of section 42, but it is worth noting that that is also how the editors of Lindley and Banks see the position. And I'm afraid that Lindley and Banks on section 42 didn't make it into the bundle. So that's in the Radcliffe Chambers bundle at tab 1. The treatment of post-dissolution profits begins at 2537 and runs to 2572. The particular passage I'm referring to here is 2538, where the editors say different considerations will, however, arise where the winding up is delayed and in the interim the business is carried on by one or more of the former partners to the exclusion of the others. And so we say, in order to satisfy that requirement here, Mr. Manduka would have had to have been excluded from the partnership business post-dissolution. The third point that I wish to make when dealing with the proper construction of section 42 is that section 42 is binary. You are either a continuing partner or you're an outgoing partner. There is no halfway house. And I'd like to take the court to two authorities on that point. The first is at tab 2 of the Radcliffe Chambers bundle, and that's Chevlew and Brown. This is a case in which there was a GP's practice in Scotland of 3 partners. One partner dissolved the partnership and left. The other 2 GPs continued under the name of the partnership briefly before starting up a partnership under a different name. In that period of continuation, they continued servicing an NHS contract that they had with the practice. And the court had to consider whether servicing that NHS contract was continuing the business for the purposes of section 42, or whether it was completing a transaction begun but unfinished for the purposes of section 38. So that was the question before the court. And the court determined that it was completing a transaction begun but unfinished, and therefore fell within section 38, therefore section 42 did not apply. But the particular passage that I rely on is at paragraph 44. And that is internal page number 166. It starts with some commentary about what has not been included in the more recent editions of Linley and Banks, and goes on to say the situation of trading with another person's property will commonly arise on dissolution of a partnership, and that the former partners will be likely to have control over what is the property of a dissolved partnership and will, for entirely good reasons, wish to continue trading in what is effectively a continuation of the business of the dissolved firm, but is nevertheless a distinct and new concern. However, for a situation in which section 42 is intended to arise, it must be possible to distinguish between an outgoing partner and continuing partners. And it goes on to talk about it's the profits made since the dissolution that are brought into account. And section 42 has no application to profits of a dissolved firm which happened to be part of the active process of winding up. And of course, that's what was found there, that continuing the NHS contract was part of the process of winding up. And we have no difficulty with that. That makes perfect sense. When an active winding up is happening, there is not an outgoing partner. So we say that is reflective of the dicta at paragraph 44. It must be possible to identify an outgoing partner. Yes, my learned leader's helpfully pointing out to me the bottom of that paragraph. Section 42 is designed to address the situation where a new concern has commenced business on its own account, albeit that the business is a continuation of the business of the former firm. The second authority that I want to turn to in making this point that section 42 is binary is Hopper and Hopper. Probably the leading case in this jurisdiction on section 42. That's at tab 41 of the authorities bundle, and it's page 834. I'd like to turn to. This was a case in which there were four partners. We had mum, dad, Mr. and Mrs. Hopper, their son Robert and his wife Lynn. There was two partnerships, both at will, a farming business and a fruit and vegetable wholesale business. Mr. Hopper died in 2003, which automatically terminated the partnerships by technical dissolution. And in 2007, Mrs. Hopper brought proceedings against her son Robert. Mr. Justice Briggs was asked to determine some preliminary issues, one of which was whether Mrs. Hopper was an outgoing partner within the meaning of section 42. That was argued by Robert. Mrs. Hopper was arguing that the partnership was effectively continuing. It was found at first instance that Mrs. Hopper was not an outgoing partner. Robert appealed on that point and the matter was overturned on appeal. Mrs. Hopper was an outgoing partner, and the relevant paragraphs are 48 and 49. 48 sums up what section 42 governs. It governs what happens in relation to post-dissolution profits if the business of the former partnership is continued by one or more of the former partners, not for the purpose of winding up, but for the personal benefit of those continuing to run the business. 2, those persons do not include all the former partners. 3, they are retained within the business, all or part of the shares of the assets of the former partnership, to which those non-participants in the continuing business were entitled. You then read down to section paragraph 49, which is where we get to the important point at the first sentence. Against that background given in para 48, the meaning and effect of section 42 are clear. All such non-participant former partners are outgoing partners. So in summary, to pull those strands together, we say, first, you look at this from the position of the business. Second, you have to find that the business can be said to be being continued, and that will require sufficient use of the assets of the firm such that the business can properly be said to be being continued. It probably is at this point just worth turning up Duncan and Marigold, the Scottish decision of Lord Justice Reed, which we've already looked at during this appeal. But at page 2036 of the authorities bundle, which is tab 40, give me notes, tab 67, at paragraph 46, Lord Justice Reed is considering what is meant by section 42, and he quotes from a Scottish text, Clark on partnership, halfway down that paragraph, just below J, between J and K, and he quotes from Clark on partnership, if on the retirement, bankruptcy or death of a partner, the others continue to carry on the business as before without coming to any settlement with the late partner, they will be liable to account to him or his representatives. So I say that, as quoted there, puts the point, the business continued as before. And I say that puts the point, as you would expect and as you need to find under section 42 for it to be engaged, that you have to find sufficient use of the assets and continuation of the business, that it is the business of the firm being continued as before.
The top of paragraph 46.
Yes.
He says that section 42 applies not only where the partnership continues, but also where the partnership assets are used by a new partnership.
That's right, because it's not just the partnership being continued, because, for example, in a two-partner firm, when one partner is outgoing and the other carries on their own, they're not in a partnership anymore, they're acting on their own, they're a sole trader. So it doesn't have to be the partnership, but the focus is on the business. The section says the business of the firm. So you could transact it under a new name, but it has to be substantially the same, that it can be called the business, carried on as before.
Yep.
Third, in drawing together those strands, I say you have to be able to distinguish between an outgoing partner who's been excluded and a continuing partner. And fourth, an outgoing partner is a non-participant former partner. So that means a former partner who does not participate in the business of the firm at all. Moving to my second topic, why the appellants say the judge misdirected himself. We've already looked at the judge's conclusion, which is on section 42, which is at paragraph 423, at page 172 of the core bundle, tab 9. And the judge's conclusion was effectively that section 42 is not binary, because he found no logical difficulty with the proposition that both men could be carrying on the business of the partnership for their own respective accounts following dissolution. We say that the judge misdirected himself in that paragraph. First, as a matter of logic, it is our case, and it was at trial, that two people cannot continue the same business at the same time in competition with each other. There is only one business. They're effectively competitors in the marketplace. They cannot both be running the business. Second, in any event, even if two people could carry on the same partnership business separately, that would make them both continuing partners. And then there's not an outgoing partner. And effectively, the judge's conclusion at 423 has no outgoing partner in the situation as he determines, in the situation in which he determines section 42 can apply, it has no outgoing partner. So we say for that reason it can't represent the proper interpretation of section 42. Third, section 42 does not apply or does not require a partner to account for carrying on a percentage of partnership business. It's carrying on the business that triggers the obligation to account.
Suppose you have a two-partner business which is split up. They each carry on the same, let's call it, type of business as the partnership carrying on. One uses what used to be the partnership's premises, and one uses its bank accounts. If you're right, section 42 isn't engaged at all. So under what principle would either be required to account for the other?
29. Because 29 looks at use of an asset.
So that you say is the sole governing provision.
Yes, I say 29, so long as it applies with the attendant breach of fiduciary duty, and that looks at use of particular assets or particular partnership property is what section 29 is aimed at, the use of partnership property. But section 42 is a different section, and that is continuing the business. And that's why I draw the distinction between how the two different sections approach liability. That section 29 looks at the actions of a partner.
You say section 29 covers a situation of breach or equivalent.
Yes.
I'm not necessarily positive that.
Sorry.
I'm not necessarily saying there would be a breach in that situation, but you'd say in any non-consensual situation you could get an account.
Yes, I mean, we do say, of course, and it's been our submission throughout this, that section 29 is fiduciary, it represents the fiduciary duty, and there must be a breach. If one partner took over the premises and the lease of the premises, it would be difficult to see on the cases we've looked at of taking over the partnership lease that would not be within section 29.
So you're saying in a situation where you've got a two-person partnership and they dissolve the partnership just by agreement, and they say, okay, you continue to service your clients and I'll continue to service mine, doing exactly the same thing we were doing before, accountancy firm or solicitor's firm or whatever.
Yes.
You say that they simply can't be, the section 42 can't apply because you can't bifurcate the business. It
Yes.
only applies where all or substantially the whole of the business is conducted by the continuing partners.
That's right, yes. We say section 42 really was aimed at the situation in which you've got maybe a death or an outgoing partner for whatever reason, and the other, it does use the word partners, although in both Pathirana and Sandhu and Gill, Sandhu and Gill was this court, the Court of Appeal, Pathirana was the Privy Council, both applied it even though it was only a two-partner firm. But we say that it is on the face of it designed to cover the situation where the business continues. For example, in Duncan and Marigold, that was a fishing business, a commercial fishing business, and it was run by 4 fishermen. One of them died. The other 3 carried on taking the boat out every day, carried on fishing, and it was about accounting to his widow for the profits in the continuation of the business.
I mean, it's slightly curious, isn't it? Because in the circumstance that I've just described, where there's an agreement to what they do, Section 29 wouldn't apply.
No, because there's an agreement, yes.
And
Yes.
yet, you say Section 42 doesn't apply either.
Yes, that's exactly right. I say it doesn't. And in fact, the Partnership Act actually is all about agreement between partners, if that is possible. I think it's Section 19 that says this act applies unless there's an agreement between partners. A bit like the Sale of Goods Act. This is what will apply unless you come to your own arrangements. I think that's Section 19.
So so what would happen? So each in the situation I've described, each ex-partner would just be entitled to keep the profits they've made.
Yes, yeah. Not least because of their agreement, but also that slightly as well harks back to we were looking at to me on partnership, the Irish text, and the point that your lordship raised about there was a reference to an accountant's firm, and actually often customers or clients, I should say, are with an accountant's firm because they have a relationship with the individual. I think I've reached my 4th point, but I'll be corrected if I'm wrong on that. But the 4th point as to why I say the judge misdirected himself on the law was that on the judge's approach for his summary at paragraph 423, both partners would have a simultaneous entitlement under Section 42. The appellants have not been able to find any case in which there's ever been a simultaneous liability to account and a simultaneous entitlement under Section 42. The respondents have not produced any case either, so we assume that there has never been a case in which there has been a simultaneous liability to account under Section 42 for 2 different partners. What the respondents do say, and it's probably worth turning up their skeleton argument, which is in the agreed supplemental bundle at tab 17, page 134.
Give me a paragraph number, please.
Yes, it is paragraph 114. And what the respondents do say there is, in the second sentence, to the extent that they did so using the assets of the former firm, each would have to give credit to the other for profit made attributable to the other's share of the firm's assets. But on that point, we've not been able to trace any authority where that has hitherto happened. But of course, we have found the authorities that say you must be able to identify an outgoing partner. It may come down to the fact that this was intended to apply in a situation such as the fishing boat example in Duncan, when, for example, there was a death of a partner and the firm continued. Whilst we're in the respondents' submissions, it is worth me addressing at this point an important point that we need to make. On the prior page at paragraph 109.1, the respondents say that the judge cannot be criticised for holding that Section 42 applied because the parties agreed that it did. That reference that the respondents are making is to paragraph 287 of the judgment, which is in the core bundle at page 142. 287, forgive me, I must have said 67. So 87. What the judge says there is an obvious situation in which section 42 can apply is that in Cameron Murdoch, where on the dissolution of a 3-person partnership following the death of one, the others continued the business. We'd agree with that. In that situation, there's no difficulty in classifying the 2 individuals as surviving or continuing, since they continue to carry on some business in partnership. Both Mr. Manduka and Mr. Hughes are agreed that section 42 is applicable in this case, even though there's no suggestion that after dissolution of the partnership, Mr. Manduka or Mr. Hughes continue to carry on its business in partnership with anyone else. That's not exactly right. What we agreed was it could apply in a 2-person firm, not that it did apply in this case. And then it said, put another way, they agree that both Mr. Manduka and Mr. Hughes are surviving or continuing partners for the purposes of section 42. Again, that's not how the discussion unfolded. And so we have included the discussion, the transcript, at page 62 to 63 of the agreed supplemental bundle. It's tab 13, apologies, I didn't have the tab. This was the exchange that has led to that paragraph. And what Mr. Justice Richards asked is whether he found himself wondering whether it was the case that section 42 could apply where there's no partnership at all following one person leaving, i.e. there's only one person left to continue the business post-dissolution. I went on to say it's entirely dependent on the facts. In our submission, if the court finds, and I say the claimants will obviously urge you to find there's a seamless continuation. We say that's not correct. We say Mr. Manduka was making use of the name with Collinson's, Hughes Veritas. And I say, well, I'll come on to say 2 things about that. And Mr. Justice Richards says, no, my question was more basic than that. Does section 42 apply only in a situation where there used to be, where a partnership is continuing? So it is section 42 concerned with a 4-partnership, one person leaves, now you've got, and I say, no, it can apply to a 2-person partnership, if that is your lordship's question. He says, I think that is my question. I think both sides are agreed on that. So the question was, could it apply to a 2-partner partnership? And I say, yes, it can apply to a 2-partnership because some of the authorities we're going to come on to consider are 2-partner partnerships. And so the question was, it's possible, the exchange was that it's possible, not that it did apply in this case. And of course, we say that had it really been agreed that section 42 applied in this case, the learned judge would never have gone on to make the finding at paragraph 423 that there's no logical difficulty with both sides carrying on the business, because that would have been a matter of agreement. But actually, he went on to make that finding because it wasn't agreed. So I say that at that point in the respondent's skeleton argument that this court can't do anything about it because it was agreed at first instance doesn't take the court, it doesn't take the respondents anywhere. And the final point that I want to touch on when dealing with misdirection is that we do say it's relevant that there was no pleaded claim for relief under section 42. And the Lindley and Banks extract that your lordships and your ladyship have at tab 1 of the Radcliffe Chambers bundle handed up this morning says at para 2572 that there's an Irish case in which it was said it was sought unsuccessfully to be argued a claim under section 42 does not need to be specifically pleaded. And that was an unsuccessful argument. That Irish case, Cronin and Kehoe, is at tab 3 of your bundle for completeness. There's not much said on the issue, but for completeness it is at tab 3 of that bundle. And the only paragraph that addresses this point is paragraph 48. Where the court says, at the very least, one would expect at the very least that this not only, well, forgive me, one would expect at the very least the circumstances which give rise to a claim under 42(1) be pleaded, as well as the exercise by the estate of the deceased partner. It was a deceased partner in this case, but of course, of the chosen option. That is because section 42 gives two options: an account for use of the capital and assets, or 5% interest at the rate of 5% per annum. So you have to plead your section 42 case and your the chosen option.
Can you, I mean, in other contexts, you can keep your options open and elect later on? Is that possible here?
That is a very good question, Your Lordship. For example, when dealing with an equitable account, you elect after witness state, or at the point of witness statements, I think, on the quantum stage. The only authority that is cited in Lindley and Banks to support that proposition is this case, and therefore I have to hang my hat on it. And it says you must plead your chosen election. So accordingly, for the reasons that I've set out, we say that the judge did misdirect himself on the construction of section 42 and therefore had the wrong test in mind when applying the facts. We say that misdirection was material, and I'd like to move now to address Your Lordships on my third topic, which is where does that misdirection leave us and what are we asking the court to do?
Just before you go there.
Yes.
I think the point you made was that it's only if the business is carried on by surviving partners in its entirety, or the continuing partners in its entirety that this bites, yeah?
It is if the business of the firm is carried on with its capital and assets. I accept that. I say it does need to be pretty much in its entirety in order to reach that conclusion.
Because the way the judge got round that argument, the way the judge dealt with that argument, I should say, is he said the business is just buying and selling kits from Acorn. And he identifies a number of ways in which Mr. Hughes and MSDL used some aspects of the partnership business, like the website or some people who've been involved in the partnership business, although they're not employees of the partnership.
They're not employees, and then Mr. Hughes they're just his friends.
Well, yeah, that may be a factual issue, a problem, but he didn't seem to find it problematic that if, as it were, that you only use bits of the business. I think you'd say that prevents section 42 applying. You can't define the business in the way that he did and say it doesn't matter which bits of it you use. Yes,
I would. I don't say you have to use every single asset. To use a maybe extreme example, if you took over the business that operated from an office and you took over the premises but you never again used the stapler, that is not, you can't say, well, I didn't use all of the assets. But you have to be sufficiently carrying on the business, as Clark on partnership said in the quotation in Duncan, as before. And we say you have to be using substantially all of the assets in order that one can come to the finding that you are continuing the business of the firm, or forgive me, not continuing, carrying on the business of the firm is the words of the section.
Because what the section then goes on to talk about is the consequence.
Yes.
Is that there's either an option to have 5% on the amount of his share of the partnership assets, or the profits, or share of the profits attributable to the use of his share of the partnership assets. Share of the partnership assets in that sense is talking about the proportionate interest
Exactly.
in the partnership.
Yes, exactly.
It's not talking about you find which
No.
state
talking-
were and who's
yeah.
involved.
So, for example, in
So the share in this sense would be what, 50-50 or?
yes,
And you say it would be net as well.
net, I
Because
do,
of
yes.
course, in normal terms on the winding up, the entitlement is only to what is left.
Yes, that was actually an issue between us at trial. I think there was some disagreement between myself and the leading counsel for Mr. Manduka at trial as to whether it was net or gross. But I think Sandhu and Gill makes clear, and that's a decision of this court, makes clear that it's net and that you have to look at the share that was used in turning the profit. So, for example,
is that case in the bundle?
it's not, because it goes to, forgive me, it goes to quantum, so it's not actually a
Okay.
live issue here. It is answering Lord Justice Snowden's point on the remedy that comes out of Section 42, but it's not actually relevant because it goes to quantum. But it would, what is said effectively is that you look at the net assets, you have to identify what share is used. So if you had a 50% share in the assets, you have to look at what profit those assets turned. And then the question comes in, well, did the partner use new capital, inject new capital, or did they use their skill? And so it's for trial actually, a quantification exercise at trial as to what that share ultimately turned as a profit.
I'm just trying to get my head around it, and maybe you're going to come on to this in a moment as to where does this all leave us. But on the judge's view in paragraph 421, sub 1, if you had a partnership which, for example, sold the test kits entirely through agents, people who made calls, collected orders in manually, made sure they were fulfilled. They went salespeople, right? And the partnership was then dissolved, and one of the partners didn't do that, but set up a website and got orders in from the website, just in a passive way, and just fulfilled the orders in response to the website. The way the judge has defined the business, that would be caught by Section 42.
Yes, and that is, we say, defined too widely. It's not as simple as the business sold tests. You sell tests afterwards, you're carrying on the business. We say that's far too simplistic a view. We say you have to look at this, the point I was addressing in my section on interpretation of Section 42, was you have to look at this from the position of what happened post-dissolution. And can you say that that was carrying on, to use the words of the section, the business of the firm with its capital or assets?
It's not a business of the same kind. It's the business.
It's exactly. It's the business of the firm. I think, in other words.
In the manner that the firm has been conducting business.
Precisely. Yes. And you can well see how that fits, for example, in Duncan Marigold, when the Marigold boat is used to continue the commercial fishing business post the death of one of the four partners, fishermen.
So just take, as you say, the more normal situation is nothing to do with general dissolution. It's where a partner dies or leaves and the other partners are going on.
Yes.
So suppose over time or immediately they do alter exactly what they're doing in the partnership as they continue their business. Does Section 42 fall away from the point of view of the estate of the dead partner?
I think it wouldn't fall away if it was engaged at the point of dissolution, but the remedy would diminish, because you would find that if they substantially changed what they were doing, they were no longer using the capital and assets of the firm to turn the profit. They were turning the profit by other means. So it would be a quantification issue that your lordship has raised.
So suppose you've got some kind of professional partnership and they're trading from premises owned by the partnership. So you were definitely using partnership capital. Immediately on the death of the one partner who was important to some aspect of the business, they say, well, we're not going to pursue this part of the business, we're going to limit ourselves in what we do, or we'll appeal to a slightly different market. Does Section 42 fall away?
I think you have to look at whether that could be said on the particular facts of the case to be continuing their business with its capital and assets. So if they are using the premises and carrying on a business that was the business of the firm, but they've just dropped one aspect. So say that partner who died handled all the online orders and nobody else knew how to handle the online software. And so post dissolution, they carry on the business, but they don't any longer sell online. They just continue filling mail orders or orders on the telephone or orders at wholesale to a shop. Then it would be a decision for the judge to decide whether that was carrying on the business, and you can see degrees of it.
I mean,
There are lots of, again, to mention tax cases, there are lots of tax cases that have to identify whether a business is still the same business despite changes. I think you're saying, is it the same, the question would be, is it the same business?
Is it the same business? Or to use the words of Clark on partnership, as before.
I mean, see, I was just thinking while you were talking, suppose you have a solicitor's firm, 4 partners, one does conveyancing, one does family law, one does crime, the other one does commercial. One partner dies, the other 3 have no idea what he got up to, you know, they don't know his area of law. So they don't replace it.
Yes.
They carry on doing their own work, and his ex-clients just they're farmed off to somebody else. But they carry on the business from the same premises using the same name without paying out his widow a share of the quote capital that was represented by the building.
Yes.
And everything else. Now, it's slightly difficult to say that that's the same business because it's missing, you know, a big chunk. It's a big chunk of it. Do you say that that stopped Section 42 operating? Because that would seem to me to be a sort of case where it should operate until the widow is paid out.
You'd have to look. You'd have to look at the degree to which the business could be said to change, but you would get to a point. I do say you would get to a point where it is not the business anymore.
Yeah, I mean, this is on the face of it. Yeah. Okay. Well,
I think the difficulty in answering your lordship's question there is I'm trying to think on my feet as to whether I can think of any authority like that. I don't think I can. For example, in Duncan and Marigold, very clearly they took out the same boat, the same fishing boat.
You understand they're going out and they're catching the same sort of fish.
Exactly. But if that were to change, I can't think of an authority in which that has been an issue and has been decided within the context of Section 42. May well be that this is need to refer to the tax cases, but within the context of Section 42, I'm struggling to think of a time when it was challenged that they were no longer continuing the business. The challenge has more been, are they an outgoing partner or are they not?
I mean, the judge.
What was the purpose for carrying on? Was it to wind up under 38 or was it to continue under Section 42 rather than positively you're not continuing the business?
But the judge's approach, as it set out in paragraph 420, would probably be to say, well, partnership's business was provision of legal services as solicitors. It continued from the same premises using the same secretarial support staff. There were 3 continuing partners. They used a whole raft of the same resource and assets, the same associates.
And if they're using the name as well, what your lordship is describing is really carrying on the business. Smith and Partners operate under that name from that premises.
So that's if you accept that that could engage section 42, then we do come down to a factual judgment, or an evaluative judgment as to whether the section actually applies to this continuation.
But what your lordship is looking at there is the question of the continuation, continuing the business of the partnership. The other aspect that we need to look at is outgoing partner and continuing partner.
That's where you came in. That's a different point.
Yes.
I mean, I'm assuming if you're right on that, then I don't think it applies. But if you're wrong on that, if you're wrong on that, I'm just trying to understand how the test works for the continuation of buying and selling of kits, but in a different way, operating differently.
What I would say, in the particular facts of this case, so no longer addressing, for example, the solicitor's firm, it's probably easier to address it in terms of the facts of this case. If I'm wrong on the outgoing and the continuing partner, and your lordships are looking at whether the business of the partnership was continued, what is relevant here is that Mr. Manduka was also operating a business, which we say was using more assets of the partnership and was more akin to the partnership business than what Mr. Hughes was doing. So that has to weigh into your factual consideration in that circumstance that you're describing.
Well,
can you say Mr. Hughes is continuing the business when Mr. Manduka is selling to the partnership customers?
There are two answers to that point. One is neither person is entitled to use section 42, and the other one is you're both entitled to use section 42 and you didn't make a claim under 42? Or you did? For Hughes Healthcare Limited, Mr. Manduka accepted that he would have to bring that business into account. So because he was selling to partnership customers. Right,
so we didn't need to make that.
Okay. Sorry, I delayed you.
Can I delay you just one moment longer? So take the typical case of someone dying, and they were carrying on. I'm going to take an extreme example. They were carrying on a solicitor's practice, but as it's happened, they're all qualified accountants too. And on the death of the one partner, they decide we're actually giving up on the legal practice. We're now going to carry on an accountancy practice, but we're going to use the same premises, which are a partnership asset. We're going to use all the partnership desks, equipment, computers, blah blah blah. So they're using the partnership assets, but it's not, we'll say, the same business. Is that a Section 38 case?
The 38 cases.
Because there's actually been a dissolution, hasn't there?
Yes, there has been. You're right. There's been a dissolution, but they're probably not continuing the business for the purpose of winding it up. And in that scenario, they're continuing it to be accountants.
So all they'd be entitled to do under Section 38 would be to continue for the purpose of winding up. So the widow or whatever would have a remedy under the general law for using her assets.
Well, if what they were doing was substantially continuing the business, there would be a remedy under 40.
But on this hypothesis, they've swapped being a different sort of business.
Then you would look at the use of assets.
Yeah, Section 29.
So it's a section 20.
29.
To my question earlier, do you say the same thing? It's section 29.
Yeah.
Yes.
Because I think in that hypothesis it is a different business.
And 29.2, of course, expressly covers where somebody dies, a partner dies.
Yes. Yeah.
You'd be there using property, albeit possibly
Yes.
the name, but not maybe the business connection, because you'd be marketing to different people.
Yes.
Yes.
But there could be a 29 claim.
Yeah, sorry.
No, not at all. In fact, Lord Justice Snowden has hit on what was going to be the first point of my third topic. Where does that misdirection leave us, and what are we asking the court to do? My first submission was going to be, there are two ways of looking at this. Either neither partner carried on the business in what I refer to as the twilight period. And that, we say, is the preferable That's our primary submission and the preferable way of looking at this, because we say there is one partnership business. It is not capable of being split and yet remaining the business of the firm. And we say in that circumstance, both partners are carrying on business that is similar to the partnership, but neither is carrying on the business of the firm. And that's, we say, one way of looking at it, and we say perhaps the preferred way. If your lordships and your ladyship are not with me on that, the other way of looking at it is to say, on the finding, if the finding that Mr. Hughes was a continuing partner, continuing the business of the firm is to stand, then we say Mr. Manduka is also inescapably a continuing partner, continuing the business. And you've then got a situation where both people are continuing partners, which is equivalent to there being no outgoing partner. And if you can't identify an excluded outgoing partner, section 42 again doesn't apply. So my primary case, although I think I've probably already covered it, is that the first analysis is to be preferred. They are both carrying on a business that is similar to the partnership business. There is accountability. We say, for example, Mr. Manduka would have been accountable for profits made from Collinson's under section 29. He's already admitted that they're coming into account, so that deals with that. But neither partner is carrying on the business of the partnership. So section 42 does not apply. And we say in that circumstance that there was a misdirection on the law and the order that Mr. Hughes' account under section 42 must be set aside.
It may be impossible to answer this in advance of trial 2, but is there clarity about what the parties are actually arguing about in relation to section 42? And it may be this question is better directed at the respondents. I understand your position to be not a lot.
Yes, exactly.
Oh yes, yes. Our position is not a lot at all, because
But for example, the profits of the Danish dealer, are they targeted under section 42 or just
Not that we're
no.
aware of.
Well, there's no pleaded claim under section
No,
42, so they certainly weren't. No.
What's the target?
So
I'm interested
the
in
assets
understanding.
under section 42 would be cash at bank, which was frozen until after the first trial. I think there was about 200,000 there. But there was also £200,000 worth of liabilities to HMRC, which Mr. Hughes has paid. And the trial judge found that Mr. Manduka would have to contribute his share to that, or it would have to come out of the partnership. And there was a name which the judge says, you can't say it had no value. We say it must have had very little, if any, value, particularly when, and this was, I don't know if it's in the judgment, so I want to be careful, but it was a matter of the respondents agreed on at trial because Frederick Manduka gave evidence that post ACON securing a government tender with their Flowflex test with another distributor, not the partnership, the Flowflex test became the test of choice.
At the moment, I'm just looking at the order the judge made, which, and paragraph 420 again. Without identifying the partnership assets or Mr. Manduka's share of the partnership assets, whatever that means, it's actually difficult to see what the substance is. I don't see how. Sorry, I don't see how that at the moment extends to the Danish contract.
No, absolutely. We absolutely say section 42 would never extend to the Danish
We don't know what was.
I mean, it's
contract.
the assets were 420. What's set out in 420, presumably to the extent that they might be thought to be assets of the partnership.
And to the extent that trial 2 finds that those assets were turned a profit, or what profit it turned.
I mean, the one that seems most obvious perhaps is the use of the website.
Yes, and we admit, as I took your lordships and your ladyship too, we admit that we bring into account, we did from the point of filing the defence, £8,816 and a penny.
Yeah, and so we'd be talking about that sort of
Yes, and the judge expressly refers, the order expressly refers to taking into account paragraph 290 of the judgment. Paragraph 290 of the judgment is the paragraph that summarises my submission that there was no value as at dissolution to be operative under section 42. And that's where the decision of the Court of Appeal of Sandu and Gill is referred to. I'll move on, if the court is content, to my alternative case, which is that if the judgment is correct that Mr. Hughes was a continuing partner based on the judgment, then Mr. Manduka must also have been a continuing partner, and therefore in that circumstance you've got no outgoing partner. And the first thing that I say about this is that Mr. Manduka, it's a matter of agreement and it's a matter found in the judgment, was trading Hughes Healthcare Limited and selling to Collinson's, who was the partnership's, apart from Newfoundland, of course, was the partnership's main client that the partnership had directly. And we say that is enough for the court to conclude that Mr. Manduka was a continuing partner if Mr. Hughes is a continuing partner and the test is that low. I do say as an aside at this point that it's relevant that appears to be how Mr. Manduka and his son saw the position, because in the appellant's unagreed supplemental bundle at tab 26, page 59, that the court has a WhatsApp chat exchange between Mr. Manduka and his son Frederick Manduka. And Frederick Manduka says to his father, Mr. Manduka, it's there on the 13th of July at 8:45 p.m. He's referring to Mr. Hughes when he says, "I thought he was informed today he's no longer allowed to say that I don't work for Hughes Healthcare. I need him to at least be told something like this. You and Philip have split up the Hughes Healthcare business. I am now listed as a director on Philip's side of Hughes Healthcare. Therefore, I am directly part of Hughes Healthcare. Anything said to the contrary, like you have been saying, is untrue." So I think it's fair to say that the parties, or Mr. Manduka and Frederick Manduka, thought that they were Hughes Healthcare post-dissolution. And in that case, I say that as an aside, it's interesting to note that that's how they saw it. And I also say that given what the judge says at paragraph 287, which was the it's a matter of agreement between the partners that they're both continuing, and I say we didn't agree that, but the judge has got no difficulty with it. So I do say there's enough on the judgment for the court to look at it and say, well, if Mr. Hughes is continuing, then so is Mr. Manduka, given the sales to Collinson's, the operation of HHL, the fact that the judge implicitly, from a cursory view, seemed to think that Mr. Manduka was continuing by virtue of paragraph 287. And in that circumstance, there is no outgoing partner. Section 42 doesn't apply. We say it's a misdirection on the law, and the order that Mr. Hughes has to account has to be set aside. However, if the court is not with me that there's enough there to say that Mr. Manduka is a continuing partner, then my alternative submission is that the judge should have made that finding, and it was only as a result of his misdirection that he did not. And just to make that good, to explain that point, Mr. Hughes advanced significant submissions in closing on the actions of Mr. Manduka post-dissolution. And these are at tab 41 of the appellant's unagreed supplemental bundle. Now, I don't propose that I'm going to read all of these out to the court because, as the court will see, it's an extensive section of our written closings, and we are, time is precious this afternoon. But why I say this is relevant, and the judge should have made that finding, is because there's a significant section of our closing there dedicated to this point. The judge found at paragraph 470, which is on page 181, 470, he said, he explains a summary of what we have said in our closing. The defendants argued in closing that PM's continuation of the partnership's business post-dissolution could be seen in his attempts to secure a supply of lateral flow tests from a company called Getin. That was a new supplier that Mr. Manduka was using to try and get Hughes healthcare tests manufactured and Hughes Veritas tests manufactured. The defendants also contend they received benefits from selling Hughes Hughes Veritas branded tests. And then he goes on to say, however, he said that because of the cross position between the parties as to whether there is a Section 42 claim or not, he's not going to consider these submissions. But that, with respect, misses the point, because the point wasn't we need to have a forward-looking Section 42 claim for you to consider these submissions. It was, I mean, the heading of the submissions is the Manduka parties post-dissolution. We submit that this is everything that was happening post-dissolution. When you look at that, you can't say that Mr. Hughes was continuing the business, because the business cannot be split. It was being carried on by Mr. Manduka, it was being carried on by Mr. Hughes. So therefore Section 42 doesn't apply. So we say that the judge was wrong not to consider those submissions. And I appreciate that we're short on time, so I'll be very brief, but we say that it was material, absolutely material, the failure to consider those submissions, because things that were included in those submissions that therefore now aren't dealt with in the judgment are, for example, a business plan for Hughes Healthcare, which is at tab 30 of the unagreed bundle that your lordships and your ladyship have open. And that...
Sorry, that was page 30, tab 30.
Tab 30 of the unagreed bundle, page 89. This is Hughes Healthcare Limited Early Ideas, dated the 19th of July 2021. And this is Mr. Manduka's own business plan, although he had sink his evidence at trial in the judgment. It said this was drafted by a gentleman named Jason Holt, who your lordships and your ladyships may remember being taken to an email by my learned leader, which was marked strictly private and confidential, and that included that Jason Holt on that email chain. That was during the currency of the partnership, that strictly private and confidential meeting. And there's talk of establishing a new business to manufacture Hughes Veritas tests. And we can see here the business plan. Establish HHL as a limited company, fold in Newfoundland, bid in the government tender with Getin, and using the name Hughes Healthcare in the email. So we say documents like this were absolutely key for the court to consider. And the confidential meeting is at tab 40. It's not. Page 40, tab 17.
Packaging.
And
Packaging 93.
And there's an intention to manufacture Hughes Veritas tests, and of course that is a partnership test, a partnership asset, this test that the partnership were developing, Hughes Veritas. And we can see at page 40, there's a discussion or commitment to commence manufacturing Hughes Veritas test promptly was made. We agreed 10,000 by July the 2nd, and that's on June the 11th. And then over at tab 19 is a partnership agreement.
Sorry, can I just play catch up for a second?
Yes.
What are you asking us to do as a consequence of these submissions?
So my intention is to, and I do ask the court to read the submissions that I'm not going to go through now at tab 41, because I say that in this alternative, when the court says, if the court says, forgive me, that there's not sufficient facts on the judgment to consider Mr. Manduka a continuing partner, I say that is as a result of the judge's failure to consider these submissions and these documents. And we say, had he done so.
Right, but what's the order that you want us to make in this respect?
So what I say about that is I say, had those documents been considered, they would have, Mr. Manduka would have been a continuing partner, no outgoing partner, and therefore there's a failure to consider relevant material. In that instance, the order that Mr. Hughes' account under Section 42 should be set aside because there's been a failure to consider relevant material as part of our defence. And I say, as an addition to that, once setting aside that order.
Why is it part of your defence? I thought this was all aimed at saying that Mr. Manduka also would have a liability under Section 42, no?
Not that he'd have a liability, that he would, if what Mr. Hughes had done was continuing the business according to the judge, then the judge should also have found that what Mr. Manduka did was continuing the business. And if two people are continuing the
No, I
business.
understand that winds back to your first point, but I was just looking at the grounds for appeal, and maybe you're not on this yet. Because I understand your point that you can't have two people conducting the same
Yes.
the partnership business
Yes.
position. You're perhaps trying to illustrate that using these examples, but does it go any further than that? Because I sort of understood that you might be then moving towards a different
I'm not
tack.
seeking a positive obligation to account, because that's not what we have permission to appeal on this ground. We advance, it's paragraph 140C of our defence and counterclaim, and this became a big issue in trial because what we pleaded Section 42 defensively. We said if anyone was continuing the business, it was Mr. Manduka.
Well, I think you're saying that if he's a continuing partner, he cannot be an outgoing
Precisely.
partner. And that's a slightly different point.
Precisely.
From your first point.
Yes,
I think
precisely.
that's the point you're
That's
making.
precisely, your ladyship has it. And therefore, if he can't be an outgoing partner, we say that we say on the judgment you can decide he's not an outgoing partner, therefore set aside the order that Mr. Hughes' account. If you don't agree with me, you can decide that on the judgment and what's already agreed or found. Then my second alternative case there is, well, it should have been found, and the only reason it wasn't was because of the failure to consider relevant material, and therefore the order should still be set aside. And the court might ask me in that instance, well, what do you say about remittance to consider relevant material? And I would say there's no case for remittance because there is not a Section 42 claim pleaded. So the court can't remit something to be considered that was never pleaded or asked for.
Now, my thought yesterday morning
Yes.
was obviously vastly over-optimistic. No one finished by lunchtime, but your side submissions do need to be finished by 4:15.
Yes, it will be.
Absolutely. I can perhaps move on swiftly and just ask the court to consider deliberating the submissions that were made that are at tab 41 that we say should have been considered. That only leaves ground 2B, which I can take very swiftly because of the time. We say under ground 2B, and I can take this in 3 points, that first, if the judge was wrong to find that Mr. Manduka was entitled to an account under Section 42, because he should have held that it would be inequitable for Mr. Manduka to enforce a right given his conduct. The second point I say is that Section 42 does not represent a fiduciary duty, of course. I don't understand there to be any challenge to that. If there is, I can go through it, but I don't understand there to be any challenge to that. Section 42 does not represent a fiduciary duty, but nonetheless, the remedy when seeking to enforce an account under Section 42, the remedy when seeking to enforce a claim under Section 42 is the remedy seeking an account. And that is an equitable remedy. And although Section 43 says that the sums due to the outgoing partner are a debt accruing at the date of dissolution, you still have to bring an action for an account to enforce the debt. So I say it's an equitable, it's not a fiduciary duty, but it's an equitable remedy, equitable jurisdiction. And therefore my third point is that given an action for an account as an equitable jurisdiction, the court can deny relief based on the conduct of the person seeking the account. I don't put it any higher than my learned leader has done in her submissions that she's already addressed this court on this morning, as to equity and the barring of one person from seeking an account. In that case, it was because there was an equitable relationship. In this case, it's because it's an equitable remedy. And I say Mr. Manduka should not be entitled to enforce an equitable remedy when in breach himself.
Your argument, it may just be that in a sense it's already been swept up. Ms. Hilliard's made the submissions in a way, but both section 29 and section 42 use the concepts of an account.
Section 40, I'll check whether the word is used an account.
So you were saying section 42
Section 42(2).
provides for there to be an account.
Well,
Ye-
section 42(2) refers back to 41(1).
Yes.
On the basis that it is a liability to account.
And my point is, and section 29 talks about an account. So is your point that the very use of the concept of an account in both sections necessarily brings in all the equitable discretions that the court has, or how does it work?
No.
I mean, why is there a difference between the submissions that Ms. Hilliard was making about section 29 and yours, if there is?
Because section 29 represents a fiduciary duty. So in that circumstance, the court is considering whether a fiduciary can seek a remedy when he himself is in breach.
Right, but if she was wrong on that submission, and we're just looking at the words,
Oh, if Ms. Hilliard and the appellants are wrong on our ground 1A entirely.
You come in charging into her assistance by saying, aha, look, the word account is used in both sections, therefore you get the equitable remedy.
Well, yes.
There's a question that was occurring to them this morning. Is one way of looking at this, and your submission seems to be looking at this way, is that because both sections talk in terms of an account, and an account is an equitable remedy, you say, it brings in the whole range of equitable principles such as clean hands, discretion.
That's what I say.
cetera.
Yes.
And if you say that for section 42, I'm just struggling at the moment to understand why Ms. Hilliard wouldn't say, yeah, me too.
She absolutely. I think Ms. Hilliard would, if the judge is right that section 29 isn't fiduciary, you just look at it on its face, then yes, we would have to hang our hat on the fact that it used the word account. But given that fiduciary duties are at play there's probably bigger concepts to worry about.
But again, I just seem to follow from your...
Yes, no, absolutely it does. Your lordship is absolutely right. It does follow from what I'm saying. That
I'm not saying you're right, I'm just saying it logically follows from what you're saying.
It does. Yes, your lordship is right that it follows from what I'm saying, not that I'm right.
I'm not committing myself.
Yes,
I haven't heard
but
this to VR or anybody else on the subject, so...
the point I make is that although the remedy is a debt, and that's said in 43, the way you enforce that debt is bringing an action for an account, and that is an equitable remedy. So I say at that point, in comes the doctrine of clean hands. Well, it's not the doctrine, it's analogous to. It's if you want an equitable remedy, then...
Well, it's a discretionary
It's a
remedy
discretionary
to be
remedy.
exercised in accordance with principles, and you
Precisely.
usually fashion equitable remedies to achieve what you regard as a just result.
Precisely. Thank you. The court has my point in much more succinct way than I was putting it, so thank you. Unless I can assist your lordships any further, and your ladyship any further, those are my submissions on section 42 on ground 2.
Thank you very much. Miss Hilliard.
I hope I can take this quite shortly. There are three There's ground 4, ground 5, ground 6 and ground 7 to deal with. Ground 4 is that the judge was wrong to find Mr Hughes, his wife and MSDL liable for conspiracy. And if we're right that Mr Hughes has no liability to account pursuant to section 29, then it inevitably follows, we say, that the judge was wrong to find that the defendants in that case, or the appellants, were liable for conspiracy to cause harm to Mr Manduka by unlawful means. The unlawful means was found by the judge, in fact, to have been Mr Hughes' breach of fiduciary duty, his failure to account under section 29 and section 42. That's paragraph 453 of the judgment. And what we say simply is that the judge should have held that as he did not, Mr Hughes didn't breach his fiduciary duty or breach section 29 or section 42, there were no unlawful means upon which a claim for unlawful means conspiracy could be based. I'm not even sure that there can be an unlawful means conspiracy in relation to section 42 anyway, but
Well, I was going to say, what's the unlawful means under section 29 or 42? They just say if something happens, then
yes.
there's a remedy. If
Yes.
you count, is it
But, well, I agree, but I mean, we're also stuck with the fact that he found at paragraph 453 that Mr Hughes breached his fiduciary duty as well, and obviously that would be unlawful means, but we say that he didn't. So, ground 5.
Well, I mean, he said in the middle of it,
Yes.
under 453, I conclude that the breach of fiduciary duty and his failure to account under section
Yes.
29 and 42 were unlawful acts.
Yes.
I mean, is that right? That your failure to
Yes.
account under 29 and 42 are
No.
unlawful acts?
I mean, there can be a breach of statute, which is unlawful means, but it's difficult to see how simply a failure to account under section 29 or section 42 is an unlawful means. You're just being called upon to comply with your statutory duty in the connection of a winding up of the partnership. I mean, the way this case came...
Sorry to rise, but with great respect, this is just not a ground of appeal. The ground of appeal is very simply, it's parasitic on ground 1. It's not to ask you to contribute to the long debate over what is unlawful means in the tort of conspiracy.
Well,
and if it wasn't 335, I might have let the argument go on, but I'm ready as a premium.
I think you were accepting a few moments ago that whether or not section 29 or section 42 could constitute unlawful means, breach of fiduciary duty would, and there's no independent appeal against a finding of breach of fiduciary duty.
What we say, if Mr Hughes is liable for any of those, then I suppose Miss Blythe and MSDL would be equally liable in conspiracy, but we say he wasn't.
Yeah, so from your point of view, it's parasitic.
Yes. Ground 5, the judge was wrong to direct that Mr Manduka's claim against Mr Hughes, Lynn Blythe and MSDL for knowing receipt of partnership assets is a matter for the second trial. Again, that's parasitic because we say that if Mr Hughes isn't liable, then there's no claim for knowing receipt. I mean, even assuming that one could establish that there'd been a receipt of partnership assets of some sort. But we say that if Mr Hughes is not liable, then there should be no claim for knowing receipt, which the judge directed without deciding should be deferred to the second trial. Ground 6 was that the judge was wrong, we say, to dismiss Mr Hughes' claim that the claimants and 3rd to 7th parties acted in conspiracy to cause harm to Mr. Hughes by way of unlawful means. What the judge found at paragraph 479 is that Mr. Hughes' unlawful means conspiracy claim has not been made good in closing submissions and accordingly fails. The point is, though, the closing submissions were very short, it's fair to say, because we were running out of time. But Mr. Hughes did plead an unlawful means conspiracy claim against Mr. Manduka and Titanium in his amended defence and counterclaim at tab 13. The relevant paragraphs are...
Sorry,
yes.
no, sorry, I forgot what you just said. Was that at tab 13?
Yes, it's tab 13.
Yes,
That's where
yeah.
our amended defence and
Yes.
counterclaim was. The relevant paragraphs, this is against Mr. Manduka and Titanium because they were the claimants in that claim. The relevant paragraphs are at 33 and 35 of the defence and counterclaim. That's page 268. So we started off at paragraph 33, setting out really the particulars of the secret profit, and then at 35, accordingly, Mr. Manduka was benefiting financially by way of a secret commission from the sales of Hughes Healthcare branded LFTs made by Newfoundland without the knowledge or consent of Mr. Hughes, and alternatively, if there was a profit share available to split within Newfoundland, then better terms could have and should have been obtained by the partnership. And immediately before that is the terms of the agreement reached with Frederick Manduka. And then at 47 and 48, is the pleading of the raising of the invoices for the secret profit. And then at 154, A to C, I just need to find it before. Yes, well, I'm guessing that, I know it's, the pleading isn't, so,
Page 354.
thank you very much. Yes, in addition, for the reasons set out at paragraphs 32 to 88 above, and are set out in the pleading of the additional claims, they were the claims against Freddie Manduka, Mike Hognett in Newfoundland, and Arari Manduka, Mr. Manduka's wife. And Neuro said, Mr. Manduka conspired with Titanium, Mrs. Manduka, Frederick Manduka, Mr. Hognett, Neuro said, to intentionally cause loss to Mr. Hughes using unlawful means. Damages are sought. The unlawful means used by the co-conspirators were the breach by Mr. Manduka of his fiduciary duty and duty of good faith, the knowing receipt by Newfoundland, Frederick Manduka, and Michael Hognett of partnership property, as described in paragraphs 36 to 40. And then at C, the co-conspirators had the intention to cause Mr. Hughes loss because it was inevitable and necessary that in making a gain for themselves, or one or more of them, the co-conspirators would cause loss to Mr. Hughes, in that Mr. Hughes was entitled to half of all the profits and the confidential information and business corporate opportunities available to the partnership, which were being diverted to Newfoundland and or Titanium and or Neuro said. And then 155A, for the reasons set out in the above paragraphs and as set out in the pleading of the additional claims, Titanium conspired with Mr. Manduka, Mrs. Manduka, Frederick Manduka, Newfoundland, Mr. Hognett, Eurosed, and or HHL to intentionally cause loss to Mr. Hughes using unlawful means. The unlawful means are pleaded at paragraph 154. and at 168G, Mr. Manduka and Titanium, we sought orders that Mr. Manduka and Titanium pay Mr. Hughes damages for conspiring with each other and or Mrs. Manduka, Frederick Manduka, Newfoundland, Mr. Hodnick, and you said in HHL. And then the relief we sought was a declaration that Mr. Manduka acted in breach of his fiduciary and good faith duties as a partner, and damages against Mr. Manduka and or Titanium for conspiracy. And I don't need, because it's pretty much pleaded in the same way, Mr. Hughes included a plea for unlawful means conspiracy at paragraph 2 of his additional claim against Orion Manduka, Freddie Manduka, Newfoundland, and Mike Hodnett and Eurosed. That's at core bundle, page 448. And the conspiracy is pleaded out at paragraph 5B of the particulars of the additional claim. That's at page 488. And paragraph 64 to 69 of the additional claim at page 469 to 470 of the particulars of the additional claim. And paragraph 2 of the prayer at page 471. Now, the judge recorded at paragraph 451, at page 177 of the core bundle, that the parties were agreed on the legal elements of unlawful means conspiracy. And we say that the judge found facts sufficient to prove unlawful means conspiracy on the part of those parties. Namely, the judge found that Mr. Manduka had a secret 30% share in the profits of Newfoundland. That's at paragraphs 292 to 310, pages 143 to 146 of the bundle. We say that the secret 30% share was a matter agreed between Mr. Manduka, Mike Hodnett, and Freddie Manduka, as illustrated by the email exchanges between Mr. Manduka and Frederick Manduka in December 2020. That's paragraph 293 of the judge's judgment at page 146, and as evidenced by the critical email dated the 25th of April 2021 from Mr. Manduka to Freddie Manduka and Mike Hodnett, copied in to Ararin Manduka, where Mr. Manduka referred to the partnership between himself, Freddie Manduka, and Mike Hodnett. And this email was referred to by the judge at paragraphs 329 to 332, page 150 of the bundle. If you want to look at that email, it's at page 28 of the Appellants Unagreed Supplementary Bundle. A relevant email setting out the profit split was forwarded to Ararin Manduka. That's referred to at paragraph 306 of the judgment at page 145. And the proceeds from the profit share were paid to Titanium and Basfor, another company owned by Mr. Manduka, incorporated in South Africa. That is at page 146 of the core bundle, paragraphs 311 and 338. And these payments that were made to Titanium, Mrs. Manduka was involved in setting up the payments. One can see that by paragraphs 325 to 328 at page 149 of the core bundle. The judge also found that Mr. Manduka diverted customers and potential customers away from the partnership to Newfoundland to the knowledge of and with the acquiescence of Freddie Manduka, Newfoundland, and Mike Hodnett. That's paragraphs 350 to 356, page 1, starting at page 155 of the core bundle. So in our submission, the judge found facts evidencing an agreement or combination Also, we say that the judge's finding that Mr. Manduka diverted business to Newfoundland and took a secret share of the profits of Newfoundland undoubtedly involved injuring Mr. Manduka's partner, Mr. Hughes, as a means of serving Mr. Manduka's own economic interests. We say that there could have been no other realistic finding on the facts found by the judge. And as for the unlawful acts carried out, Mr. Manduka secretly shared in Newfoundland's profits and operated in business and in competition with the partnership with Freddie Manduka and Mike Hodnett through Newfoundland, and diverted partnership leads to Newfoundland in breach of his fiduciary duties owed to Mr. Hughes. If Mr. Manduka had not breached his fiduciary duty, this is in terms of loss suffered by Mr. Hughes, we say the loss suffered by Mr. Hughes as a result of the unlawful acts and the combination was axiomatic, because if Mr. Manduka had not breached his fiduciary duty to Mr. Hughes, either because he disclosed to Mr. Hughes the opportunity to receive 30% of Newfoundland's profits and brought it into the partnership, or the partnership was able to make an increased profit on the sales to Newfoundland because Newfoundland would not be paying 30% of its profits to Mr. Manduka, Mr. Hughes would have benefited from the extra profits generated by the partnership. And additionally, if Mr. Manduka had not diverted leads to Newfoundland when properly the leads should have been exploited for the benefit of the partnership, there would have been a greater profit for the partnership and accordingly a greater share of the profits payable to Mr. Hughes. The judge declined to make a finding of conspiracy because, as he found at paragraph 478, the defendant's closing submissions did not explain why the participants in the alleged conspiracy should be taken as having an intention to injure Mr. Hughes. And then he went on, of course, I understand that intentions can sometimes be inferred from the nature of the actions. However, care is needed before making such an inference, given the distinction between an outcome that is an end in itself, a means to an end, and a foreseeable consequence. And he refers to Lord Hoffman's speech in OBG and Allen. And he went on saying, before drawing any inference as to the presence or absence of the requisite intention, I would have required fuller submissions as to precisely what inference I was invited to draw. Now, despite saying this, when considering the claimant's conspiracy claim against the defendants, the judge was prepared to make inferences, and one can see that at paragraph 455. He finds that causing harm to Mr. Manduka was accordingly the natural and inevitable consequence of the unlawful means that were employed. The requisite intention to cause loss by the unlawful means was present in the light of the analysis of Lord Hoffman as to the nature of that intention set out in, it should have been, I think, paragraphs 42 and 43 of his speech in OBG. As the judge was prepared to infer that causing harm to Mr. Manduka was the natural and inevitable consequence of the unlawful means that were employed, it really doesn't make sense that he was refused to draw any inference as to the presence or absence of the requisite intention as far as the conspiracy, which was there in black and white between the members of the Manduka family, the companies, and Mike Hodnett. And we say that the judge should have made a finding of conspiracy on the facts against Mr. Manduka, Titanium, Freddie Manduka, Mike Hodnett, Newfoundland, and Araran Manduka. First, because the...
Can I just...
Yes.
I mean, you haven't shown us the closing submissions, or...
They were... I accept...
For either side,
no.
But, I mean...
They were very short. I accept that.
Is the judge sort of saying, well, one side actually made some submissions to me and actually made their case to me and the others didn't?
Well...
I mean, is that...
But I don't say that that's an acceptable way for a judge to proceed.
Well,
If the facts are there, and they were, in black and white, to then not find, particularly as the other side are making exactly the same claim.
Well, that's what, well, hang on.
Yeah, sorry.
It is quite unfair generally to criticise a judge for not finding something he wasn't asked to find. So haven't we got to look at your closing submissions?
Well,
And haven't we got to compare them with the ones that you led to him making what you say was the other
Yeah.
finding on the other side?
what we said in our closing submissions, our written closing submissions, is that we would make those submissions orally. And I think we did make some oral submissions, but frankly, we ran out of time. That was the problem. I mean, that's really what happened. But I mean, what I'm not criticising the judge necessarily for not reaching, for not dealing with it if he wasn't happy with the submissions that we made in closing. But post-closing, he sent three emails to the parties about areas that they're in the agreed supplemental bundle, about areas that he was unclear about. If he had any difficulty with the way in which we were putting our case on unlawful means conspiracy, I do say that he should have asked us then, because as far as we were concerned, the facts were there in black and white, and the claimants had been running their case using exactly the same authorities, arguing it in exactly the same way. So from our perspective, and particularly as we'd run out of time, the facts supported an unlawful means conspiracy, and the judge should have so found. I mean,
is your case that, are you saying, well, the issue was there before the judge?
yes, it was
The
pleaded.
issue was there.
It was pleaded.
It was pleaded.
It was there in
And
our opening written submissions.
I think you're saying that it's essentially not open to a judge. not to
Exactly.
decide something that is an issue before.
Yes, and that is there in black and white. Otherwise, and I put my
Whatever
hand up.
assi-
Otherwise,
whatever
somebody that
assistance.
doesn't do it properly, that the poor client suffers, and that's not right. If the facts are there, that the case has been pleaded, which I've shown you it is, and the inevitable conclusion that the judge should have reached is that there was a conspiracy. It can't be right that the judge can just say, well, they didn't plead it, so the client has to go
Well,
away
it
with
doesn't say they didn't plead it.
well, they
What do you-
didn't. They didn't make submissions at the
He
end.
just says in closing submissions, you didn't satisfy me
Yeah,
as to an essential element
Yeah.
of the tort.
and what I'm saying is that he should have been so satisfied, because if you look at the facts,
Are we going to see what you're actually said in your
well,
closing
yes, I'm just
submissions?
trying to find out where they.
I mean, if we haven't got it already, then it could be provided to us
Yes,
by
we'll
tomorrow
provide it
morning.
to you. That's a good idea. That's a good
Let
idea.
me put my own friend out of her misery. It's in our unagreed supplemental bundle. So if you want to look at it now, we can. Yes.
So perhaps we should just have a look at it.
Respondents unagreed bundle. Tab 19.
I haven't got tabs.
It's claims. It's claimants skeleton. Claimants written closings. No, it's. I think it's tab 21.
We haven't got tabs. Your opening starts at page 81, I think.
Yes.
92 is closing.
So just take it by stages. Opening, I
Yeah.
suppose, in fact, this is the extract dealing with unlawful means conspiracy, running
Yes.
from
So that starts at page 84.
84 through to 88.
Yes.
And then the closing submissions begin at page 92,
Yes.
and there you deal with that starting at 93.
And we do say at paragraph 409 that the defendants will deal with conspiracy, the dishonest assistance claims, and the knowing receipt claims in oral submissions. And it's fair to say we ran out of time. That was the problem.
So, so the earlier parts are dealing with the law, which applies
Yes.
both ways,
Yeah.
and then you have 408, 409.
Yes.
and then orally in closing submissions.
I'm not sure that that's in the bundle.
We've got a bit of transcript. I don't know whether that includes. Does Mr. Brown know that? Is anything at all said in closing submissions? I mean, maybe I don't know. Well, you can think about that by tomorrow
Yes, I
morning.
will.
Just taking the stage further for a moment. I assume you'd say, well, you have already said, well, so far as Mr. Manduka is concerned, on your case, it's perfectly obvious. If he's taking a secret profit and diverting business, then that's going to be to the prejudice of Mr. Hughes, and he must amend that. But you've got a number of different conspirators. Does it work as neatly as that in relation to all of them?
Well, in relation to the diversions, he was diverting opportunities to his son and Newfoundland, and Freddie Manduka must have known because he was getting the opportunities, and then he was going off and exploiting them or trying to exploit them, and therefore that would have been, we say, it was unlawful again of Mr. Manduka, and Freddie Manduka was involved in effectively agreeing to that arrangement.
And Mrs.
Well,
the judge focuses on intention to injure. Mrs. Manduka,
Well,
Mr. Hoddenot.
The facts of Mrs. Manduka, the judge actually goes through. There were two aspects. First of all, the original email discussing the profit share was copied in to Mrs. Manduka. The subsequent email, and it's all in the judgment, the subsequent email round about April, where Mr. Manduka is criticising the two young men for not paying their debts on time and describing himself as being in partnership with him. That email is also, Mrs. Manduka is included in that email. And there's another aspect in the judgment which he also refers to, where Mrs. Manduka was cross-examined about various payments being made to Titanium, and it was put to her in cross-examination that they were the profit share that Mr. Manduka had agreed. She denied it, but the judge didn't believe her evidence.
You said she was involved in that?
Yes.
Setting up the payments, I think you said.
Yes, and she drafted the invoices to Newfoundland, because the case of Newfoundland and the case of the co-conspirators was that they were loans. The payments made to Mr. Manduka were loans and not a profit share, and the judge didn't believe that evidence.
Can I just, sorry, again, just playing catch up, sorry, it's late. The unlawful means conspiracy is said to exist between Philip Manduka, his wife, Freddie Manduka, Newfoundland, Mr. Hoddenot, USCD, or others. As I think Malia said, or said, the inference you say is obvious. You attribute to Philip. Is that right? I mean, but
yes,
but.
Well, and also I would say it's obvious. It's obvious to the other co-conspirators.
Okay. Can you have, if you have an agreement
Yes.
to do something which is unlawful, can only one person be liable because they had the requisite intent and the others don't?
No, they all have to be liable because
all have to have the requisite intent. So if one of them doesn't have the requisite intent, the others can't be liable.
no.
Sorry, let me
No,
put my
sorry.
question again. It's a bad question.
I mean, as I understand it, if you allege a conspiracy against three, and it
Yes.
turns out that one of them doesn't have the intent, but the other two do,
Yeah.
well, you win on
Yes,
against the
you
two.
What about the more difficult point? If one person has the requisite intent but the other two don't, is that still an unlawful means conspiracy as against the one who did have the intent because there was a combination and there was an unlawful act and just two people didn't have the intent?
Well, I think that's the racing.
The reason I ask
Yeah.
it is because if you look at 478,
478.
the judge seems to say, before drawing any inference of the presence or absence of the requisite intention from what OM, FM, Newfoundland and others actually did, but he doesn't mention Philip Manduka.
Well, I
He
mean,
doesn't seem to have a problem. He
yes.
doesn't raise a problem about the requisite
Philip,
intention of Philip Manduka, and as somebody said a moment or two ago, your primary target of the unlawful conspiracy claim, and you say who must obviously have known that what he was doing would injure Mr. Hughes, and therefore he must be taken to have had the requisite intent to injure, was Mr. Manduka.
Well,
He's not the one the judge seems to have any problem.
You don't need this head to make your claim against Mr. Manduka.
no, I don't.
This
No.
claim is in order to widen the net. Isn't
Yes, it is. Yes.
So
What have to say, I'm not sure. You've drawn our attention to various factual findings. They don't necessarily relate to the entire list of people that you have in your conspiracy.
They do. They all relate to the entire list. We've got Freddie Manduka and Mike Hodnett, who are first of all, you've got the initial agreement with Freddie Manduka.
And you've made reference to the position of the wife, but there
Yes.
are others in this list. Aren't there?
No. Well, we had Neurasaid, but that's not worth powder and shot. And
You're
HHL.
not aiming. So
No,
who are the people you're aiming at? With this?
Mrs. Manduka, Freddie Manduka, Mike Hodnett, Newfoundland, and Philip Manduka. It's those individuals that we appealed against.
Again, I assume if you won against the individuals, you wouldn't actually care about Newfoundland.
Don't know, because Newfoundland's maybe quite well. It did very well. Whether it's still got money, I don't know.
But it's owned by
Yes.
individuals against whom,
True,
on this hypothesis, you would have claims.
True. Yeah. I mean, it's you have to assume that Newfoundland paying out invoices to Mr. Manduka knew, bearing in mind that Mr. Hodnett, well, not Mr. Hodnett didn't give any evidence, but Freddie Manduka was saying it was loans, and when it was actually Mr. Manduka's profit share, that Newfoundland and Mr. Hodnett and Freddie Manduka recognised or should be inferred as recognising that what they were doing was necessarily involving injuring Mr. Hughes to achieve the ends that they wanted to achieve, namely to advance Mr. Manduka's economic interests at the expense of Mr. Hughes.
And I think we've got your case on this. I have in mind we've got 20 minutes left.
Right. Well, that it's just one final ground then, which is that we pleaded a knowing receipt claim against Titanium. That's ground 7, and that was at for the notes paragraph 155, in particular paragraph 155H. Paragraph 168D of the amended defence and counterclaim. That you can find that at page 357 of the core bundle, and paragraph 7 of the prayer. That's page 361. And the judge found that during the lifetime of the partnership, Mr. Manduka made a secret profit, being 1/3 share of Newfoundland's pre-tax profits. That again is paragraphs 292 to 338, page 143 of the core bundle. That was a breach of fiduciary duty by Mr. Manduka, paragraph 460, page 179, and that Mr. Manduka should account to the partnership for his secret profit share. That's at paragraph 460 of page 179 of the core bundle. He also found that Titanium received this secret profit share on behalf of Philip Manduka, thereby rejecting Philip Manduka's argument that the transfer of monies from Newfoundland to Titanium was a loan. That can be seen from paragraphs 311 to 335 and paragraph 315 in particular. That's pages 146 to 147 of the core bundle. Mr. Manduka was the sole director and shareholder of Titanium until after the partnership's dissolution. And as the judge found, Titanium was a repository for Mr. Manduka's business dealings. That's paragraph 164, page 117 of the core bundle. Yet, the judge neglected to make any finding in the judgment on Mr. Hughes' claim against Titanium in knowing receipt when dealing with the other accessory liability claims at paragraph 475. That's page 182 of the core bundle. Now, at the consequentials hearing, we did argue that the findings in the judgment should lead inevitably and inexorably to a finding that Titanium was a knowing recipient. Again, we can give you the transcript on this, but I've got the bit of the transcript. In response to our point on this, the judge said, I mean, it seems to me that the knowing receipt claim was dismissed, and the reason it was dismissed was because no submissions were made on the state of knowledge of the relevant recipient. For better or worse, that's what I did. I didn't mention Titanium in paragraph 475, no doubt because of a slip on my part, but reading the judgment as a whole, I don't think there's any sense from the judgment that the claim against Titanium was being upheld or was being permitted to go to trial too. And what we say, again, that was wrong. The claim was pleaded, the facts were there to support the claim, and the judge should have ruled on it, not just simply said, well, no submissions were made on it.
Just out of interest, did you make the same point in relation to the claim in conspiracy?
I do.
Did you?
Yes, I did. Oh, what in?
At the you said at the consequences hearing.
Well,
you
no,
objected.
no, I don't think we did, because the knowing receipt claim, the judge didn't even deal with it.
No, but
Yeah.
Your criticism on Underground 6 seems to boil down to the fact that the judge had the material in front of him.
Yes.
There was a pleaded claim. Instead of just saying, poof, you're out of time, sorry,
Yeah.
you lose. You say he should have actually put two and two together and made four.
He should have decided the claim.
Decided the claim. You say similarly in relation to knowing receipt.
Yes, except that
He didn't, but you raised the knowing receipt problem at the consequentials hearing. And I just was asking.
no, I didn't, because it seemed qualitatively different in a way, because he actually didn't make any. He didn't make
This is
any
his
finding.
slip. What he says was his slip in not referring.
Yes,
to
yes, yes.
So that was the basis.
We
on
drew
which
that
you
to his
raised-
attention. We drew that to his attention, I think, in the draft, when the draft was going around. Yes, I mean that it was qualitatively different, because the conspiracy claim he actually found against us because we hadn't made any closing submissions. The knowing receipt claim, he didn't make any finding because he just missed it out in paragraph 475. So what I say in relation to both those
Although
claims.
paragraph 13 of his consequentials judgment on page 188 would be as equally applicable to the conspiracy claim.
Yeah. But my point is that all the facts were there, the facts were pleaded, and yes, it was unfortunate that we ran out of time, but if the judge was troubled by that, bearing in mind that he sent us at least 2, if not 3, emails wanting us to provide submissions post post the trial, he should have asked us, because it can't be right that just because there aren't, at the end of the day, detailed legal submissions on a claim that is fully pleaded and where the facts are all set out, that the judge can just say, well, it's not proved. Because
But again,
it was proved on
overnight,
facts.
it might be helpful if you could draw together anything bearing on
Yes, I will.
what you said at trial.
Yeah.
Just looking at the opening skeleton, I can see it does have knowing receipt as well.
Yes.
I mean,
It sets out the legal.
Yes.
Sets out the legal. So all he needed to do, and I'm not. And this isn't meant as I'm not trying to be overly critical of the judge. I mean, it was a long trial. It was exhausting. But all he needed to do is fit the law that we'd set out in closing to the facts that he'd found.
Well, I mean, can you turn to page 189 of the consequentials judgment? It's page 189 of the bundle.
Yes. Sorry.
I mean, it's just worth looking at paragraphs 15 and 16 of the consequentials judgment, which seem to deal with the conspiracy claim.
Well, we did run out of time.
Yeah, but I mean, which bit of that?
Well, we ran out of time, in relation to getting in the closing submissions by the requisite time, which is why we said that we would address oral submissions at the oral closing, and then when we got to the oral closing, we ran out of time again. So that was the difficulty.
So is your argument that it's a procedure? What's the ground of appeal, that it's procedurally unfair?
Yes, it was procedurally unfair.
So this is what, a case management decision?
No, it's not. Look, I think what one needs to do is that the judge is there to decide cases fairly. Taking something really rudimentary, if you had a litigant in person that set out all the facts but didn't really quite have the law right, it's not good enough, I say, for the judge just simply to say, well, the litigant in person hasn't set up the law, so I'm not going to deal with it.
So in paragraph 15 of that judgment, the judge said he had specifically directed the parties to ensure that their written closing submissions superseded the opening and dealt with all points that were being pursued in closing, so he wouldn't need to resolve for himself potential differences between written and oral submissions.
Mm-hmm.
I mean, is that right?
He did say that he wanted to ensure that their written closing submission superseded the opening skeleton. No, he did say that.
So that he wouldn't need to resolve potential differences between them.
Yes, but afterwards he clearly had further questions, because he sent us emails that he wanted us to. So he was still wanting further submissions.
He makes the point in 16. I mean, the trouble is, I'm beginning to sort of see here that a judge who's dealing with this massive piece of litigation with some loose ends gives directions that aren't complied with. As a consequence, doesn't deal with the things that weren't complied with, and now he's being criticised for not having done that which he warned he wouldn't do if he didn't produce the submission.
It was that direction. It was given at the PTR, and I don't think we remember him giving any reason for it, other than it was understood that best endeavours, we would try and put together the opening skeleton with the closing skeleton, so that everything would be in one place. And as far as we were concerned, everything was in one place.
Can I just ask you about that? We ought to break in a moment, but I'm looking back at the opening submissions.
Yes.
And we've looked already at what it says about unlawful means conspiracy.
Mm-hmm.
And then it comes on to your claim for knowing receipts
Yes.
at paragraph 125. This is 89 to 90. So paragraph 125
Yeah.
refers to the legal test, and then you get 126, 127.
Yes.
This doesn't refer to titanium.
Just a second.
I mean, maybe we're best leaving it for
Yes.
you to think about overnight.
Right.
And I'm assuming that this didn't get into the closing submissions at all, but I may be wrong. Again, you can think about that.
Yes, I will. Yeah.
I'm assuming, just for the sake of good order, that other than responding to any query that your lordship's just given her, that is the end of Ms Hilliard's and Ms
Yes.
Rogers' submissions.
I'm assuming that too.
Another long day, but if you'll forgive me, I don't want to start generally, but it goes to the very point that we're talking about. The oral closing submissions are at tab 18 of our unagreed bundle.
We would need page numbers again. We do not
It's,
have
of course,
tab.
page 59. They are indeed brief. Page 59, starting at line 13, Ms Hilliard said this was, as you cannot see from the transcript, just after 1 p.m. on the last day of the trial, I think, and she says, I need to address you very quickly on what we say is the remainder of the claim and
Sorry,
counterclaim.
you're at page.
59, my lord.
Yeah, sorry, I'm just going to pick up where you're reading from.
Line 13 and 14.
Then I think I need just to address you.
So this is just after 1 o'clock.
Exactly,
I assume that means that Miss Hilliard had to finish at 1 o'clock.
I assume so. Then she refers to the racing partnership case, which is a decision of this court about knowledge. She says at lines 20 to 21, we do say there was an unlawful conspiracy here. You can read what she says over the page. And it finishes at line 4 on the next page. And that is it for the conspiracy claim, those 15 or so, what is it, 15 or so lines. And then she moves on to the knowing assistance, dealt with at an equally high level. And,
But when you say knowing, I assume this is dishonest assistance. This isn't knowing receipt.
yes,
Knowing receipt.
fine. Knowing assistance was the phrase used.
Sorry, this is referring to knowing receipt. isn't it?
Yes,
There's no titanium.
There is at the bottom.
uh,
Titanium receiving tranches of secret profit.
yes.
Where is that?
18 and 19.
This is the receipt claim dealt with again very
Well,
briefly.
it is receipt claim, is it? Because after that it says we say that that was all dishonesty assisting.
Both, yeah.
I think, to be honest, Ms. Fair, thank you for drawing our attention to the passages. Let's come back to
Sure.
tomorrow. So, Ms. Hilliard, you're done.
Yes.
Save for just anything else to say on
Yeah.
this particular aspect.
And also anything we can find on what textbooks and so forth have said on business connection.
Yeah.
Historically, yeah.
In which case, we'll leave it there for tonight. Thanks in the morning.